Welcome back to Advocacy, Alchemy. Let's watch a video together, guys. This is here credit to Queen City News. This is a short one this morning, okay? Welcome back to Advocacy Alchemy with Professor Ross. Today we have a good one, guys. Well, this is also going to be a heavy one. We're looking at a moment where the legal system and human heartbreak collide. We're in North Carolina at a courthouse, and this news report comes from a hallway. We've all heard of fighting words, but what happens when those words are spoken by a person accused of killing your child? Today, we're analyzing the case of Shaheem Snype, a father who reached breaking point. We're going to dive deep into the law of retribution, the reality of bond hearing, and the little feeling that tells a parent when the system has failed. Let's watch this together, and this is one that's going to be short, guys. I want you to actually comment on this. How do you feel about this whole thing? With that, let's jump in.
A Charlotte father getting national attention for this incident right here. It was all caught on video. He's accused of attacking the suspect charged in the murder of his son. Emotions clearly very high right there. There were also two other victims who survived the May 2024 shooting, including one who was paralyzed. A Queen City News reporter David Schumann spoke to that victim's mother about the courthouse brawl.
The man on the attack in this video is Shaheem Snype, and all those punches and kicks are directed at Marion McKnight, who's accused of shooting and killing Shaheem's 16-year-old son, Jamariah Dixon, last year in Charlotte.
All right, so just so you know, the person is being attacked. Look, he has a leg monitor on. That's a part of his release, pretrial release. Okay, we'll look at all the documents. I have all the suspects' documents, and when I say suspects, I'm talking about the murder suspect, the young man with the blue shirt on. He's 20 years old, so he's not a child. Okay, now he did kill a child. All right, let's watch what happens. That's the father there who's swinging on him right there. Okay. Let's watch.
Letha Perry says Snype is a hero.
What Jamariah's dad did, it put smiles on all of our faces.
McKnight's charged with murder in Jamariah's death, but Talitha's son, Nazir, was also shot during the same incident. McKnight's charged with his attempted murder. Nazir was paralyzed from the waist down.
Got shot through his main jugular. He lost his life 2 times. They brought him back.
Talitha says their days are now filled with doctor's appointments, PT, OT, nurse visits.
I relive it every day. I cry every night. I thank God he spared my son's life, but our life is just drastically changed.
Despite the murder charge and prosecutors arguing against it, a judge granted McKnight bond. That led to the encounter with Snype last week at the Mecklenburg County Courthouse. It was before a hearing about revoking McKnight's bond. Prosecutors say he violated the travel and social media conditions the judge set. McKnight went to the hospital after the attack, and the bond hearing will be rescheduled. McKnight's lawyer said in a statement, "This was the most violent assault I've seen in a courthouse in my 22 years as a lawyer. Any parent can sympathize with the intense grief of losing a child, but the violence we saw in court on Thursday was unacceptable." He also says the shooting was self-defense. Talitha wants McKnight behind bars, though, as her son continues his recovery.
He wasn't moving at all. He couldn't even talk at a time. So, by grace of God, we're moving in the right direction.
In Charlotte, David Schumann, Queen City News.
Wow. Shaheem Snype, the father seen in the video, now charged with a misdemeanor assault charge.
Okay. All right, so we're going to look at the laws here. Then we'll look at the documents, guys. Like I said, this is a very short one. Now, the father was only charged with simple assault, which is a misdemeanor, okay? That's the charge you get when you're fighting and you're caught fighting, okay? We have similar charges over here in Arkansas, but in North Carolina, this is where this is at. This is in Charlotte, North Carolina, all right? So let's jump in, let's hear the law, and then we'll go over the documents. Okay, so in North Carolina, that's where we're at. This is in Charlotte, hence the Queen City News. What you just saw is a textbook example of simple assault. This is defined under the North Carolina General Statutes, section 14-33. Now, under the law, an assault is an overt act or an attempt to cause immediate physical injury. To prove this to a jury, the state must show, first, that the assault was committed. Second, it was intentional. And third, there was no legal justification. Now, let's talk about the defense of retribution. Now, here's the hard truth for the defense. Retribution is not a legal defense. Now, you might be wondering, what is retribution? That is the old biblical eye for an eye. The law does not recognize that this man deserved it, or that a person can use that person killed your son as a justification for physical attacks carried out in a courthouse. Now, because this happened in the courthouse, Mr. Snype, he also faces direct criminal contempt as a potential course of action against him. Now, this is the judge's way of maintaining the sanctity of the court. Now, even though your gut feeling may tell you the father is a hero, the law still views him as a defendant. Let's move into our evidentiary standards next. They're always important anytime we're going to be dealing with the police or if we're going to be called to court. Okay. All right, I know a couple of those went by fast, but we're going to look at the actual laws. One of them said bond revocation, and because that's one of the things that they've been fighting over for a while about revoking this young man's bond because he's been violating their conditions, okay? We're going to take a look at those documents right quick. Let me get them pulled up and we'll be right back. Okay, so as you see here, we got the Google Drive open, and all of these are going to be available. If you're seeing this right now, these documents are available. You can come through and peruse them and see what this looks like. These documents mostly are from the young man that's on trial for murder, okay? So that's why there's so many documents in here, and that case is still going on. It's probably going to go on throughout the summer before it's over, okay? Let's take a look at the law first, okay? So I have the laws pulled up here. All right, misdemeanor assaults, batteries, a phrase. An affray is a fight, okay? That's what a tavern fight. That's what a affray is. It's an old school word, all right? And you have simple and aggravated punishments, all right? So it says any person who commits a simple assault or simple assault and battery or participates in a simple affray is guilty of a class 2 misdemeanor, all right? What does class 2 misdemeanor carry? Let's see if we have it here available. I think it's back down here. All right, so notice that a person can be placed on community punishment, which is probation for that, in addition to any other punishments imposed by the court. Now also look at this second one here, down here. If you've been convicted of this more than once, second or subsequent violations, it's an automatic 30 days in jail. All right, no less than 30 days in jail, along with any other punishments the court sees fit. All right, so it's not a serious charge, guys. People get into fights all the time. They're not treating it like a very serious charge here, okay? Now, he might be held in contempt, and what contempt is basically where the judge says, okay, this is over and above whatever you're being charged with criminally, okay? This is because you acted up while in the judge's presence or in his immediate purview. Right outside the courtroom, in the hallway where you're supposed to wait until they call you in, that's in the immediate purview of that judge who's presiding over that case. They can put him in jail for up to 30 days. They can put him in jail for actually up to a whole year, all right? And it doesn't count toward this charge, but usually it's considered to be it's not supposed to go beyond I think a class, probably C misdemeanor where I'm at, and that means, anytime you're going to charge them more than $500 or put him in jail for more than 30 days, you need to have some really good points of why you're doing that, okay? Now here they can hold him in jail for a couple days if they wanted to. Now I will say that he, in the end, probably will not receive very, very large of a punishment behind this because he might be put on probation and he might come off of that probation after this case is over. So if that young man is found guilty of that crime or those two crimes, because he has what we would call a first-degree battery if you shoot someone and they don't pass away. And he also has a murder charge. He probably has an attempted murder charge he's dealing with too. But let's take a look at all those charges here in just a second. The next law, criminal contempt. This is found at 5A-11, okay? Willful behavior committed during the sitting of the court and directly tending to interrupting its proceedings, all right? So if they were still dealing with stuff on the inside, they had to pause, send bailiffs out to go make sure people don't tear each other apart. Willful behavior committed during the sitting of the court in its immediate view and presence and directly tending to impair the respect due its authority. You have willful disobedience, resistance to, or interference with the court's lawful process, order, directives, or instructions. A willful refusal to be sworn or affirmed as a witness. Willful publication of a report of the proceedings in the court that is grossly inaccurate and presents a clear and present danger of imminent and serious threat to the administration of justice. This is when most courts don't allow you to record or to blog from the courtroom unless you've had prior authority that's been, given to you by the court. So when a person or is a news reporter and they're in the courtroom blogging, or somebody's secretly recording the process, you can be held in contempt. Willful or grossly negligent failure by an officer of the court to perform his or her duties in the official transaction. So this is dealing with a lawyer. Officers of the court are lawyers, okay? Willful or grossly negligent failure to comply with the schedules and practices of the court resulting in substantial interference with business. That's when somebody doesn't show up when they're supposed to. All right, you can hold somebody in contempt for that. Willful refusal to testify or produce other information upon the order of the judge. This is when the judge tells you you must testify. All right, willful communication with a juror. All right, so this is during a jury trial. If someone tries to communicate with a juror after the judge has started the proceeding and inform everyone what the process is, and that no one should talk to the jurors and the jurors shouldn't talk to anyone else during the process of that trial. Let's see. Willful communication with the juror to influence the deliberations, okay? When the defendant fails to comply with conditions of probation, they also can be held in contempt for that, all right? But so on and so forth. Like I said, you can hold someone in contempt. Let's see if they have how much time it is. I don't think I have it in this one. All right, let's move on to the next one. But like I said, usually up to 30 days, and then you have to have some good reasoning why you're holding someone beyond that. And that's what we learn when we go to Reno to judge school. So they tell us all that stuff. All right, 14-51.3. Use of force in defense of person, and this is a relief from criminal or civil liability. Remember, his attorney, the young man who was in a fight with the father, all right, the suspect, the overarching suspect, okay, this is his defense. He's claiming self-defense. A person is justified in using force, except deadly force, against another to the extent that the person reliably believes, let's make this bigger, that the conduct is necessary to defend himself or herself against, or another against others' imminent use of unlawful force, all right? A person who uses force as permitted by this section is justified in using such force and is immune from civil and criminal liability for the use of such force unless the person against whom the force was used is a law enforcement officer or a bail bondsman who was lawfully acting in the performance of his or her official duties, and the officer or bail bondsman identify himself or herself in accordance with the applicable law. So they have that law. If you happen to harm a law enforcement officer, they had to have identified themselves, letting you know they are a police officer or a bail bondsman. All right, procedures for determining pretrial conditions of release, okay? There's going to be several documents you see in this file talking about conditions of pretrial release. Everything started to happen May 27th of 2025. That's when the arrest happened. That's when he went in front of a magistrate. They do have magistrates over here in North Carolina. That's the lowest level judge. He's going to set the initial bond, and then it goes right up to their higher court, who's going to deal with these felonies. Okay, I think it's the Superior Court that it's called here in North Carolina. All right. So in determining the conditions of pretrial release, all right, they can deal with the release of the defendant on his written promise to appear. That's a release on a person's own personal recognizance. That's what we call it. The release of the defendant upon execution of an unsecured appearance bond. All right, this is without a commercial bondsman. And then number 3, to place the defendant in custody of a designated person or organization agreeing to supervise him. That's a bondsman, commercial bondsman. Require the execution of an appearance bond, specified amount, by cash deposit of the full amount of the bond or mortgage. This is when somebody has a secured bond or a secured cash bond, or they put up a mortgage on their house to promise that they're going to appear. You also have house arrest with electronic monitoring. The young man had an ankle monitor on, okay? Then you have some more information here. This is a longer statute. You can take some time and go through this one, and you can comb through it. But look at this. A person has to be seen in North Carolina within 72 hours. Now, they have a special provision. If so happen, everything's closed due to weather, or you have some holidays that fall together, 96 hours if they can't be seen within the initial 72-hour period. Okay? All right. And now we have the actual information that I found on the criminal defendant in this case, Marion McKnight. All right, that's a young man that's 20 years old who shot the other two young men, and one of them passed away. All right, here's his case, 25 CR 319353-590. It's in the Mecklenburg Superior Court. Mecklenburg is a county that houses Charlotte. Okay, so we're not talking about a very small city. Charlotte's a pretty good sized city, guys. It's about maybe 400,000 people who live there. Might not be the biggest city compared to where everybody lives, but it's a pretty good sized city. That's why you have that big building on the cover page is the courthouse. Okay, it has probably about 13 floors there or so. All right, so it's warrants. We have all these documents. That's what all of us in the jump drive, or not jump drive, but the Google Drive. And let's take some time and let's take a look at some of these. We've named them so they're easy to find in here. Let's look at the affidavit of arrest. All right, this is going to be the first thing that comes up. On May 23rd, 2025, at 5:14, they respond to this address, assault with a deadly weapon call. All right, heard gunshots coming from Stroud Park Court, and 2 individuals were shot. They arrived at the scene. 2 victims with apparent gunshot wounds to their bodies. A third victim arrived at the hospital with a gunshot wound to his ankle. So it must have been, well, I don't know what it must have been. There was a lot of shooting going on. We can say that much. Both victims were transported to the hospital by a medic. Homicide and crime scene, CSI, were investigated. Crime scene investigator, CSI. Observed the black man pull a firearm and several individuals and shoot several times. All right, they identified this young man. So Marion McKnight, that's his date of birth there. So as you see, he was 20 years old when this happened. He's 21 now. Okay, so he just had a birthday last month. Oh, detectives observed McKnight running back to the back of this. He was arrested. So police were already on the scene. They saw him do it? I don't know. All right, but like I said, you guys can come in here and review some of these documents. All right, here's the arrest warrant. So affidavit for arrest goes out first, and then you go to a judge and request a warrant if you don't catch a person at the scene right then. You also go and get an arrest warrant after a person's in custody for a judge to determine probable cause and continue to hold the person until a bond is set. All right, so this is the charge. This is the charge they're going. It says felony. That's what the F is, first-degree murder. Remember we talked about yesterday for the Fifth Amendment, infamous crime. An infamous crime is a felony. Okay. All right. Magistrate conditions of release. This is from May 27, 2025. We also have the findings of fact. Now, the findings of fact is not very much here. This is a checkbox deal. So this is what the magistrate works from when they're trying to check off what this case is going to be about. All of this documentation goes back up to the Superior Court judge, who's then going to look at this the next day and determine what type of bond, if it needs to be altered or if they're going to let it stay in place. All right, step 2, review available information relevant to setting release conditions. All right, They looked at the report. They looked at a person's criminal history. Let's see. And this was all done by Judge Cheney on May 27, 2025. Here's the conditions themselves. All right, there's the case number. Oh, he was not released. Let's see, he's required to provide some fingerprints, DNA. All right, so initially he was not released. All right, so that means the next day he's gonna go in front of a superior judge and they can make a decision. All right, because of the crime itself, he received a no bond initially. Let's look at this one. I think this might be the next day. Let's see, Mecklenburg. Let's see if I can make this a little bit bigger because it's so small. Nope. All right. All right, so this is the next day. Release not authorized once again, and this is signed by the superior judge. This is the very next day. All right. Here's the grand jury indictment, okay? This is all the witnesses they presented. Marion McKnight did unlawfully, willfully, and feloniously, and of malice, aforethought. That means this means they're going after first-degree murder. So when they're talking about malice, aforethought, they're talking about a person's mens rea. That's a Latin word, Latin term. It's talking about a person's thoughts and having the I'm at a loss for words. Basically, it's when you have the malice aforethought. It just means that you were already planning to do this crime, premeditation. That's what I'm looking for. To kill and to murder. I don't know how to say his name. I think it's Jamari Dixon. See, I don't see where they charged him for this other guy he shot and this severely injured. All right, here's the appearance bond. $100,000. When they set this bond? This bond was first set 11/14, so that means he did about 6 months in prison or in jail, in confinement, waiting on his first bond. So they gave him a $100,000 bond. Now let's look at the concerning pretrial release. Oh, it looks like they reduced it. Defendant's bond should be set at $50,000 secured. All right, that means he needs to have a bail bondsman or he needs to put up a mortgage or something that secures that he's going to return to all of his court appearances. He'll be on an electronic monitor and he should reside at his mother's residence. All right, he's restricted only to travel within a 1 mile radius of his mother's house. So he's basically on house arrest. He can only leave the house for work, church, medical care, attorney visits, or school. That's it. He's going to be monitored 24 hours a day. Any violation, and he'll be right back in jail. Let's look and see what this one is. All right, that's the initial one. They set it for $100,000, okay? Let's look at what day this one came out. This is November 17th, and this one is, okay, they did both of them on the same day. I wonder if he had two bonds that he had to bond out on. It's the same case. No. That's interesting. What's the time of these two? This one's at 3:14 p.m. and this one is at 3:15 p.m. Okay, maybe his clerk may have prepared one and the judge signed it, but then he came back and said, no, I said something different during court, and we're not doing the $100,000. We're going to do less and do $50,000. So just a minute later, he signed this other one. All right, this is the one that's in effect. Then the one for $50,000. It's changed a couple times, guys. All right, so those must have been the first two. They're all from the same day. Motion to revoke bond. This is an important one, guys. Okay, this is from February. This is from a couple days ago, guys. This is from that incident. All right, they put a motion in, and then the next day, you had all that stuff going on. Comes out of the state of North Carolina by and through their undersigned assistant district attorney. So they call the state's attorneys district attorneys over there, okay? All right, this is what they're moving under. This statute here, to revoke the defendant's current bond, and it's for the above reasons. He's charged with 3 counts of attempted first-degree murder after he shot 3 unarmed people. Now, how are they claiming self-defense, guys? All right. They have to go against his defense, but how are they claiming this? A 16-year-old, a 22-year-old, and a 23-year-old. This is the one who passed away. This is the one who's in that wheelchair. I think this might be the one who got shot in the ankle. Look, he succumbed to his injuries 4 days later on the 27th. 22-year-old paralyzed from the chest down. 23-year-old got shot in the ankle, but he has recovered. He's blessed. All right. He got a lot of charges looking at. So actually, no, it was right. It was a $50,000 bond on one person, a $100,000 bond for the other 2 cases. Probably $50,000 may have went to just dealing with this person. They wanted a total bond of $1 million at first. He got dropped down to $250,000. So that means somebody had to put up $25,000 to get him out, have him out and about walking around and stuff. All right. After hearing the arguments, he said, $100,000 secure bond, $50 for the combined 2 counts, so $150,000. That's what it ended up being. So I'm talking before I even read it. All right. He ordered release. He must reside at the mother's house, so on and so forth. Now they have concerning the pretrial release conditions. Bond out of custody on Friday, November 14th. January 29 of 26. Look, he's posting stuff online. If you're in trouble, guys, or if you're dealing with a lawsuit, don't go to the internet talking about your case, okay? You see what his account name is? Little Shit Popper. Come on, man. Can't make it up. January 30th, TikTok account and usage. Located the public account and began he'd been posting for 3 days straight. All right, so they submitted a preservation request to TikTok. That means TikTok is going to save that account and save all the activity on it. They're going to compile it down, and they're going to send it to the police. All right, detective screen recorded the account. Look, guys, they're telling you exactly how this stuff works. All right, so keep this in mind. This is how this stuff works. They obtain those screenshots, and they're going to use them right against him. Everything he says can and will be used against you because it's on public access. Defendant, he made the account private and inaccessible on February 10th. So he got word from somebody, hey, look, man, police looking at you. Or somebody got to him and said, hey, man, you need to stop posting stuff online. All right, his account was made private. He had generated 92 followers, followed by 126 users, and had received 154 likes on his posted content. Look, they're going down to the brass tacks. All right, take this also. You all be careful also who stuff you're looking at, who stuff you're liking, because in other contexts, I will tell you, the government and the police can get into these systems and they can see exactly who was looking at the content too. Don't be fooled. All right, I went to a class and we learned how to break into iPhones and Android phones. We learned how to deal with all these systems. If you don't believe me, look up the National Computer Forensic Institute in Hoover, Alabama. okay? They teach us how to do all that. And if you're working with the police, if you work for a police organization, they give you the equipment when you come there, all right? They taught us how to use it so we can understand how this electronic stuff works, how stuff does not go away, all right? Let's jump back in. He violated his geographic restrictions. That means the GPS restrictions on that monitor. Either he was taking it off or he was shielding it some kind of way so it doesn't read and send the pings back to let people know where he's at. He was gone for 28 minutes. He went to his grandma's house. He was there for 40 minutes. Look, they to brass tacks, guys. This is 39 pages of stuff. You can come back in here and look at it. We're not going to go over all of it. This is my first time actually coming back through and looking at this stuff. Look, here's stuff on Facebook. Every time you somewhere you ain't supposed to be, look, they're going to go back and see, is this his house he's in? Out drinking. Being foolish. There for everybody to see. The jury's going to see it too. That's why when you're an attorney, you have to always be vigilant with your clients. Make sure they're doing exactly what you tell them to do. I tell people all the time, hey, look, listen to your attorney, answer his phone call when he calls you, all that kind of stuff. All right, we talked about retribution, eye for an eye. Do not take revenge, my dear friends, but leave that room for God's wrath. All right. It is mine to avenge, I will repay. Eye for eye comes from here. Exodus 21, 24 through 25. Eye for an eye, tooth for a tooth, hand for a hand, foot for a foot, burn for a burn, wound for a wound, bruise for a bruise. All right, that's the old law, okay? It's not good law. It's not going to get you out of trouble if you do something like that while you're in these United States, okay? All right. And I have one more law down here. Okay, that was just talking about the misdemeanor assaults. We already talked about that. All right, guys, so this is all those documents. Look, and this ended up taking us a little bit longer than I thought. Let's listen to the evidentiary standards. Then I'll let you go for the day. We will have a body cam video that will release later on after I get off from work. So let's go to the evidentiary standards. Okay, let's work through these evidentiary standards. We'll start with the lowest. Okay, and before we get too far, that's the courthouse there, okay? You see how big that building is? And I said 13 floors. It probably has what? 1, 2, 3, 4, 5, 6, 7, 8. They have about 9 floors there, okay? They probably have a jail that's in the basement down below where we can see, and they can house some people there and bring them up to those different courtrooms as they need them, okay? All right, let's jump in. Work through these evidentiary standards. We'll start with the lowest and work our way up to the high. All right, so first, mere suspicion. Now, mere suspicion is only when the police have a hunch, but they don't have any real evidence they can point to just yet. Mere suspicion is what brings the police to wherever this incident is. Here, if a deputy sees a man looking angry in the hallway, that's only mere suspicion. They can't take any action based on someone looking angry. Now, what will happen is the police will go on high alert. In that situation, they're going to watch him. And as soon as he goes into the realm of some violation, then they'll take action. Moving up one level, you have reasonable suspicion. This is when there's more than a hunch at play. This is when the officers or some government agent can point to specific facts that suggest that there's criminal activity taking place, or you may have heard that there is criminal activity afoot. This is where a brief investigation can happen, and this is also the level of the Terry stop, which is an investigative stop. Now keep in mind, these investigative stops can only last so long. So we're talking about somewhere between 15 and 30 minutes. A good example is if Mr. Snype started shouting threats at the defendant, then a deputy could briefly detain him to de-escalate the situation. Moving up one more level, probable cause. Now at this level, this is where someone's going to get arrested. This is the standard known for legal arrest. This is when the police have gathered enough evidence that would lead a reasonable person to make the conclusion that they have enough evidence to make an arrest. So the moment that Mr. Snype threw that first punch on camera, the deputies had probable cause to believe a crime had been committed, and that crime is assault. Now you have to remember also the location where this assault happened, in the hallways of a courthouse. Next, we move up to preponderance of the evidence. This is the first level where someone can bring someone else to court to sue them for money or based on the breach of a contract or because of a tort, which is an injury a person is seeking a civil damage from. Civil just means people mostly are fighting over money, okay? In order to win these type of cases, you need to have 51% of the evidence in your favor. You can lose by having that same 51% out of your favor. And this level of preponderance of the evidence just means that it's more likely than not that the claim you're bringing is true. So if the defendant, Mr. McKnight, if he sued Mr. Snype for medical bills, he don't have to prove it was more likely than not that Snype caused his injury. Moving up one more level to clear and convincing evidence. Now, this is a higher bar, but it's also mostly used in civil setting. It can be used in a criminal setting for the purposes of setting a bond and for the purposes of enhancing a person's sentence. This level means that it's highly probable or substantially likely that the claim a person is bringing is true. To win these types of actions, you need about 75% of the evidence in your favor. Now, you mostly see clear and convincing evidence used when you're talking about people's licenses being subject to some sort of review. And I'm talking about professional licenses, but also in some instances, your driver's license, if it's going to be revoked. You see this also in family law cases when people are fighting over their children, certain medical instances where people are going to be involuntarily committed. Let's talk about an example here. Now, if the state wanted to prove that Snype is an unfit person to be a part of these proceedings or in the building when they're having proceedings dealing with this case, they would need some highly reliable evidence. And they could use the video from this fight to say that, well, he needs to be segregated from the defendant if he's going to be allowed in the proceeding. And it just simply means to separate them, either by having them in another room, having him participate through telephonic means or something like that. Finally, we have beyond a reasonable doubt. Now, this is the gold standard. This is going to be used in every criminal case in America. This level means that there is no logical conclusion that a person can come to besides the defendant being guilty of the charges brought against him. Keep in mind that this standard has to be met for each element of the crime that the state brings against a person. For a jury to convict Snype of assault, there can be no other logical explanation for his actions other than the intentional violence that he committed against this other person, Mr. McKnight. So it does leave you to ask, does grief create doubt? That would be for the jury to decide in this case, okay? Now, what I will say is how this turns out, this is only a simple assault, okay? So there were no serious injuries, so he's probably looking at a misdemeanor. There may be some enhancement because it happened in court, but it's probably just going to be a misdemeanor. And also there is that factor of the passion involved. It's a father who lost his son to this person. All that's going to come into play also. So if he took this to a jury, it would be up in the air on how they would decide this issue, because you would have 12 people that would have to come to a decision. And many times that's a part of the golden rule that you can't break. You can't say, jury members, put yourself in the shoes of this person. No, that one's not allowed. Now you can say, imagine if you knew someone and they had this happen to them. Now, as we wrap this up, let's talk about our intuition. Now, from this video, you can see the tension before that first punt. The deputies probably felt it also. The family felt it. That same intuition is often our subconscious processing tiny red flags before our brain catches up. Now, once you knew the story behind this, I'm sure it probably changed how you feel about this whole thing. It's not just two people fighting. There's a story behind why they're fighting. But there's a lesson here. The law is designed to be cold because our feelings are hot. When Mr. Snype saw the man accused of murdering his son, his gut feeling was likely screaming for justice. But in the eyes of the court, justice is a process. It's not a punch. Let me ask you before I let you go, if you were on this jury, could you set aside your empathy for a grieving father to follow the letter of the law? Or would your intuition tell you that some crimes are justified? Let me know what you think in the comments below. Does the system fail victims when it grants bond to murder suspects? You tell me. Don't forget to like, subscribe, and share the video with someone else. Remember, this is Advocacy Alchemy, and I am Professor Ross. I'll see you later on today with a body cam lecture. In the meantime, everyone be smart, be safe, and I'll see you later. Have a good day.
I order you to come back tomorrow for another lecture from Advocacy Alchemy. Dismissed.
Okay, thanks for watching with me again, guys. I hope you learned something. If you have any questions, drop them below, and I'll get to your questions also, okay? With that, everybody have a good day at work. I'll see you this afternoon.